One of the most common questions I'm asked as a real estate attorney is, what happens if my property goes into foreclosure? Can the lender obtain a deficiency judgment against me? And to answer that question, I really need to talk briefly about what we mean by the term deficiency. Probably best way to answer that is to give you a hypothetical. And the hypothetical would be, suppose that a borrower owes $500,000 on a house. That's the amount of the outstanding balance on his loan. And suppose he's not able to make the payments and the house goes into foreclosure. The foreclosure sale occurs and the only amount of money that the lender is able to obtain is $400,000. What we call at that point the difference between the $500,000 that's owed and the $400,000 that is acquired at the sale, that $100,000 is the deficiency. So the question is, under what circumstances can a lender collect that money from the homeowner when the property goes into foreclosure? Well, the first thing that's important to understand is that in order for a lender to collect a deficiency, they have to proceed by what's called judicial foreclosure. And that only occurs in about 5% of the cases in California on residential property. But it can occur, and there are some circumstances where a lender might choose to do that. But California is what we call one of the few states that has anti-deficiency protection. And the anti-deficiency statutes were designed to protect homeowners who would lose their home and then subsequently have a lender collect the deficiency, the difference between what they owed versus what the property obtains at a sale. For a home to qualify, or for a loan to qualify for the anti-deficiency protection in California, there are some important conditions that have to be met. One of the first conditions that has to be met is that the lender, when the borrower took the loan out, the borrower intended to live in the property. If the borrower acquired the property as an investment or for some purpose other than living there, then the anti-deficiency statute would not protect the borrower in the event he defaults. A second condition is that all of the money on the loan has to have been used for the purchase of the home. For example, sometimes when people buy a house, they want to use some of the money for remodeling or for purchasing an automobile. And if they acquire that type of loan, that's called a cash-out loan, and that loan will not be protected by California's anti-deficiency statutes. And a third thing that has to have occurred in order for a person to have the anti-deficiency protection if they actually default is that from the time they took out the loan until the time of default, they cannot have refinanced the property. Because when a person refinances the property under California law, ordinarily they will lose that anti-deficiency protection. There are some exceptions, but for the most part, they will lose that anti-deficiency protection. Sometimes people take out what's called a second loan on the property. The primary loan is referred to as the first because it's in the first position in the event of a default. The second loan is something a person would take out usually after they purchase the property, if they want to remodel or purchase something, and they use the home as collateral for that second. The second is not purchase money, therefore it is not protected by California's anti-deficiency statutes. Now sometimes a person will take out a first and a second when they're actually purchasing the home, and all of the money in that situation does go for the purchase. When they do that, the loan would have that anti-deficiency protection if all of the other requirements are met. Another question that I'm commonly asked is, if I do a loan modification, will I lose my anti-deficiency protection? And the answer is ordinarily no. The reason that a loan modification typically, as we use the term in California, typically would not cause a person to lose their anti-deficiency protection is there's no deed of trust, no new deed of trust recorded on the property. The deed of trust remains in place, and they simply modify the terms of the loan. And when they do that, ordinarily that would not cause them to lose their anti-deficiency protection.